Hello, and welcome to Administrative Remedies, because you can't fix what you don't understand. Brought to you in part by the University of Tulsa College of Law. I'm Gwendolyn Savitz, an associate professor here at TU and the associate dean of research and intellectual life.
And I'm Mark Rourke. I'm the dean of the College of Law.
We'll be breaking down complex doctrines with real-life analogies and examples to demystify the world of administrative law for everyone trying to understand how government actually works.
Agencies are the main way the federal government gets things done. It's not through Congress, for reasons we'll be addressing over the course of this series.
Mark, last episode, we spent 30 minutes on the hearing level picture. We talked about judge-level variation of up to 46 points on the same claim, and another 10 or 15 points of variation between hearing offices. And we also talked about the representation effect, that your approval odds are roughly doubled if you have counsel representing you. And finally, we talked about the fact that that is likely because the sophisticated lawyers can navigate this better because they built up private knowledge about specific judges and specific offices.
Yeah, and the point was that none of that is controlled by any top-down mechanism at the ALJ level, that the agency has some binding interpretive rulings, but they cover a narrow band of questions. Everything else is private. It literally is like a free market of dispute resolution, and that ALJ judgment on one side with the experienced counsel's ambient knowledge on the other.
So the natural move, once you've seen that, is to say, okay, fine, maybe the hearing level doesn't produce consistency on its own, but there's another layer above that. Every agency has some sort of review. We've got the Appeals Council at Social Security. We have the Board of Immigration Appeals. We have the Commission at the SEC, the Board at the NLRB. So even if these ALJs are producing inconsistent decisions themselves, there should be these bodies above them that can correct errors, smooth out conflicts, and pull the outcomes towards consistency. That should fix what the hearing level doesn't.
Yeah, and today's question is really, does it?
Right. So today's question is what it does, because the answer is it's not really just one thing. It's three things. It's three different kinds of agencies. And none of the three is what the textbook might suggest.
So we're not going to land on internal review doesn't work.
Right. We're going to land on something more interesting. Internal review does different work at different agencies. And the kind of work it does at each one tells us something about what it actually means for an agency to review itself.
Okay, so let's start with what they're looking at. When the Appeals Council or the BIA or the SEC Commission opens a file, what are they actually looking at?
So they're looking at a transcript and the written exhibits and whatever briefs got filed on appeal. And that's essentially it.
They're not really looking at the hearing itself.
Right. So the APA says that the hearing record is the exclusive basis for decision. Here's 5 U.S.C. 556.
Okay, it says the transcript of testimony and exhibits together with all papers and requests filed in the proceeding constitutes the exclusive record for decision.
The exclusive record. So this means the reviewing body is working from paper. They don't see the witnesses testify. They don't watch the claimant shift in their chair. They don't see them wince when they stand up. Everything that the ALJ observed in the room that informed that credibility finding, none of it is in the transcript.
And a couple of episodes ago, we talked about how credibility findings are essentially unreviewable on appeal because you just weren't in the room.
Right. So that's how federal courts are viewing it. But the agency reviewing bodies can operate under a slightly different rule. So here's 5 U.S.C. 557.
Okay, it says on appeal from or review from the initial decision, the agency has all the powers which it would have in making the initial decision. All the powers, meaning they can redo the case from scratch, even the credibility findings.
Yes, even the credibility findings. On paper from a cold record. So the ALJ, who sat 3 feet away from the witness and watched her testify for 45 minutes, makes a credibility finding, and a commissioner board can reverse it based on reading a transcript. That's not them abusing their power. It's what the APA says they can do.
Okay, that seems kind of messed up, actually. I mean, when we think about what the powers of discretionary review are, that seems wildly out of the park. Federal courts reviewing a trial court's credibility finding vastly differ on what they find. They just can't redo it from a cold record. The trial judge saw the witness.
Yes.
But the agency review body is able to redo the ALJ's credibility finding, and then the federal court reviewing the agency defers, again, because the agency is the finder of fact.
So the one party who actually saw the witness, the ALJ, is the one whose credibility finding gets replaced. You can't just swap in a finding that she did make eye contact when the ALJ who was there said she didn't, but you can change the outcome that flows from that finding. The asymmetry runs in the wrong direction.
Okay, give me a concrete example.
All right, let's take an SEC insider trading case. So the respondent goes through an evidentiary hearing in front of an SEC ALJ. The ALJ watches the respondent testify across multiple days, watches the government's cooperating witness testify, makes a series of credibility findings that the respondent's explanation of the trades are plausible, that the cooperator is shading testimony to fit their cooperation agreement, and the ALJ finds insufficient evidence of scienter and dismisses the proceedings. So under the SEC rules, that initial decision doesn't become final on its own. The Enforcement Division petitions the commissioner for review, and the commission, who are 5 politically appointed commissioners who oversee the Enforcement Division, take the case. They read the transcript. They didn't see the respondent testify. They don't see the cooperator. What they see is a paper record where the trades look suspicious and the respondent's explanation looks constructed after the fact. So they reweigh credibility on a cold record and reverse. Violations found, sanctions imposed.
Okay, and the federal court reviewing the commission?
So then that court applies substantial evidence review to the commission's determination, not to the ALJ's. The original credibility finding is gone, and substantial evidence is a deferential standard. The court's asking whether a reasonable person looking at the record could reach the conclusion the agency reached, not whether the agency reached the right conclusion.
Which means if the record contains evidence pointing in either direction, the agency wins. I mean, that's usually possible to reach either conclusion from a record that has evidence that runs on both sides.
Usually possible. So the practical effect is that the ALJ who saw the witness gets overturned, the commissioner board that didn't see the witness gets deferred to, and the person who lost in that room can't recover. The asymmetry survives all the way through federal court.
Okay, I want to flag something before we move on. You picked the SEC for that example. Is that because every agency works the same way, or because the SEC is the place where all the powers language really bites?
So that actually does matter for this episode. The APA default, the all the powers language, that's the statutory baseline. But individual agencies have some regulations that can pull back from that baseline. Social Security has one, immigration has one, and they pull back in different ways and to different degrees.
All right, let's look at the SSA regulation then. First, since that's the one that affects the most people.
All right, so here's 20 CFR 404-970.
Okay, the Appeals Council will review a case at a party's request or on its own motion if there appears to be an abuse of discretion by the administrative law judge, there is an error of law, the action, findings, or conclusions in the hearing decision are not supported by substantial evidence, or there is a broad policy or procedural issue. Okay, that language, not supported by substantial evidence, that's the same deferential standard the federal court then will apply later.
Right, same standard, and they've moved it back to the review stage. So here, the Social Security Administration wrote its own regulation that constrains the Appeals Council below the APA default. The council can't just decide it would have weighed the credibility differently. It has to find that the ALJ's conclusion isn't supported by substantial evidence in the record, meaning a reasonable person couldn't have reached that conclusion. That's a much higher bar than we read the transcript differently.
So the scenario where the Appeals Council just substitutes its own credibility call from a cold transcript, that's not really what's happening at SSA.
Right, not on the front end. The constraint's real. The SSA problem is different, and we'll get to it. It's mostly about review not happening at all and about what the agency does with new evidence. Immigration walks back the APA default even further, though with a different regulation will be when we get to Model 2. So the picture is a spectrum. We have the APA default at one end. Agency heads can redo everything. We've got Social Security in the middle. There's substantial evidence trigger for review. And immigration at the far end, a clear error review of facts, the strictest constraint. The enforcement agencies operate closest to the default. They're the place where all the powers isn't a theoretical baseline, it's the operating standard.
So each agency has effectively decided how much of the APA default it actually wants to use.
Yes, and those choices weren't necessarily made by Congress. They are made, in many cases, by the agency themselves through their own rulemaking. That's worth remembering for the rest of the episode.
Okay. Let's talk about the record. The record the reviewing body sees, can parties add to it? If it's new evidence that comes in after the hearing, can it come in at review?
It can sometimes, but the window is narrower and it narrows further at every stage. So let's look at Social Security, for instance.
Okay. That was the rule that required the evidence to be new material, tied to the period before the hearing, and likely to actually change the outcome.
Right. It was 4 requirements stacked on top of each other. And on top of that, you also needed good cause for why the evidence wasn't submitted earlier.
So what qualifies as good cause?
The regulation lists a few things, like the agency might have misled you, or you had a limitation that prevented you from submitting it, some unusual circumstance like a serious illness or destroyed records, evidence that you were actively seeking it but didn't receive it in time.
Okay, walk me through what this looks like when it goes wrong for someone, though.
All right, so here's the common version. A claimant's treating physician wrote an opinion a year before the hearing that would have directly addressed what the ALJ ends up denying the person based on. And nobody submitted it, maybe because the representative didn't know it existed, or maybe the claimant didn't mention it, maybe it got misfiled. The hearing happens without it, and the ALJ denies it.
And the representative finds it after the hearing.
Right, and so they try and submit it to the appeals council, but it's too late. There's no good cause for why it wasn't in the hearing record, so the appeals council declines to consider it. Then the case goes to federal court.
And the federal court reviews the record the agency had.
Right, which didn't include this opinion. So the court doesn't ask whether the opinion was persuasive. It asks whether it's in the record. It isn't, so the person loses, not on the merits of this opinion by the doctor that didn't get in, but on the procedural failure to get it there.
Okay, but could she refile?
So she absolutely can. You can always refile in Social Security, but the problem is that when you refile, you have a new onset date. If her original application was filed in 2020 and she refiles in 2026, she's losing years of back benefits. This can be tens of thousands of dollars.
So every stage after the hearing is damage limitation, not really a fresh opportunity.
Yes, that's a good way to put it. And the implication for review is important. If the record at the hearing is what it is, if the evidence that would have changed the outcome wasn't in the file, then even a well-intentioned review body can't fix it. They're looking at the wrong record. The hearing is the only real opportunity to shape what every subsequent reviewer will see.
All right, let's get to the question we opened with. What does the review layer actually do? Because I'd guess just from the volume issues alone, the different agencies handled this very differently.
Yes, dramatically differently. So we're going to look at 3 different models. Each one represents a genuinely different answer to what review means at an agency. So the first model is Social Security. The Appeals Council receives hundreds of thousands of requests for review every year, and it grants review in maybe 15 to 20% of cases, which is still quite a lot if we're talking hundreds of thousands of requests for review. But the rest get a one-page denial that says the Appeals Council has denied your request for review. There's no analysis, there's no engagement with the arguments, there's no explanation of what they would have looked at.
Okay, so most Social Security claimants who appeal to the Appeals Council do not actually get reviewed.
Right. They don't, and it's not just that. It's that the design of the denial letter itself is one of the cleanest examples we can see of the consequences of procedural design, even if it's not intended to be that way. So unrepresented claimants can misread it, and when they misread it, they lose their case. We talked about this a couple of episodes ago, but there's more to say. This isn't something anyone designed to produce this effect. It's a procedural artifact, but the effect is real.
Okay, take a second, walk me through the intricacies of this.
All right, so the Appeals Council denial of review is the procedural event that triggers the claimant's right to file in federal court. The denial letter is the gate being opened. The claimant has 60 days from the date of the letter to file a civil action in federal court. Once they miss this window, the right is gone.
And the letter itself?
So the letter itself is a paragraph. It tells the claimant that the Appeals Council denied their request for review. It doesn't analyze their case. It doesn't engage with their arguments. It doesn't explain in plain terms that they have the right to sue the Commissioner of Social Security in federal court within 60 days. That information is somewhere in the boilerplate, but the letter reads to a lay reader like a final rejection.
Because it's a final rejection at the agency level.
Yes, this is why we have this consequential mismatch. So denied in ordinary usage means you lost. Denied in this administrative law usage means you've now exhausted your administrative remedies. The 60-day clock to federal court is running. Those are practically opposite, but the letter doesn't make clear that it's the second one.
Okay, so unrepresented claimants see the letter and apply the ordinary language meaning and think, I'm done.
Right. So they think it's over. They don't file. The clock runs out. And by the time they figure out that they did have a right, they didn't exercise it. Their time is gone. And so is the case. Represented claimants, meanwhile, know that this letter is just a checkpoint before they can finally file in federal court. They've been expecting it. They filed the appeal in federal court, and the case proceeds.
Which connects back to everything we said in the last episode about privatized knowledge.
Right. So the meaning of this denial letter, which is the most consequential piece of paper the claimant potentially receives in this entire process, is information that's easily available to experienced counsel and not meaningfully available to somebody who's unrepresented. It doesn't really explain itself, at least not in a way that the people it's impacting are likely to understand. And I'm not saying that the people designing this were trying to mislead. This is just an artifact of administrative law vocabulary meeting ordinary language expectations. But the effect on these unrepresented claimants who take the letter at face value is still that they lose a case they wouldn't have necessarily lost.
Yeah, so in this model, review mostly doesn't happen, and the review denial itself produces outcomes through a mechanism unrelated to the merits.
Right. So the summary denial functions as a case-ending event for a huge percentage of unrepresented claimants. The ALJ's decision stands. Whatever inconsistency existed across the thousands of ALJs is preserved, not corrected. So Model 1 is this exhaustion step, not necessarily a correction mechanism because they're not correcting so many of these. And the exhaustion step itself is where a meaningful percentage of unrepresented claimants lose by default.
Let's talk about Model 2.
All right, so this one's immigration. Immigration judge decisions get forwarded to the BIA if either party appeals. So the BIA then either conducts full review or issues a summary affirmance, a brief order that sometimes might just be a sentence saying affirmed for the reasons stated by the immigration judge.
Okay, but what happens when the BIA does do full review?
So this is where things can get different from Social Security. In Model 1, the cases the review council doesn't review just disappear. The ALJ's decision stands, nothing about it travels anywhere. The BIA can designate decisions as precedential, and when it does, those decisions bind every immigration judge in the country. So the same review body that issues one-sentence affirmances in most cases is also selectively making law that governs every case that comes after it. The stakes of which cases get full review are a lot higher than they look.
Before we get to which cases get reviewed and what becomes precedent, so before we really look back to the spectrum we set up earlier, you said that immigration walks back the APA default at its furthest.
So here, let's look at 8 CFR 1003.1.
The board will not engage in a de novo review of findings of fact determined by an immigration judge. Facts determined by the immigration judge, including findings as to the credibility of testimony, shall be reviewed only to determine whether the findings of the immigration judge are clearly erroneous. Clear error. That's a standard the Federal Appeals Court uses in district judges' findings.
Yeah, so the BIA can't do what the SEC commissioner can do. It can't sit down with a transcript and decide that the asylum applicant's flat affect reads as evasive rather than traumatized and substitute its own credibility call. If the IJ found the testimony credible, the board is stuck with that unless it's left with the definite and firm conviction the IJ got it wrong. Immigration's constraints on fact-finding is the tightest of the three.
Which makes immigration look like the agency that has its house in order. The fact finder is protected.
So, yes and no. The review problem with immigration doesn't live at that factual level. The BIA reviews applications of facts to law de novo, whether a credible applicant's experience adds up to persecution, or whether a group counts as a particular social group, or whether there's a nexus to a protected ground. Those are where outcomes live, and the bigger lever sits above the board entirely.
Which sounds more like what a listener might hope internal review looks like.
It's closer, but the piece that makes immigration different from the model you might be imagining is that the Attorney General can reach into any case at any stage and decide it for himself.
Okay, just to be clear, though, the Attorney General personally?
Yeah, so let's look back at 8 CFR 1003.1.
Selected decisions designated by the board, decisions of the Attorney General, and decisions of the Secretary of Homeland Security will be published and serve as precedents and in all proceedings involving the same issue or issues.
So when the BIA does decide to write, it can bind every immigration judge in the country, except the board itself, which is still free to change their minds. Here.
Okay, so it says, except as board decisions may be modified or overruled by the board or the Attorney General, decisions of the board and decisions of the Attorney General are binding on all officers and employees of DHS or immigration judges in the administration of the immigration laws of the United States.
So let's look at the regulation that lets the Attorney General pull in the case in the first place. This is 8 CFR 1003. We looked at D, we looked at G, now we're looking at H.
Okay. It says the board shall refer to the Attorney General for the review of its decision on all cases that the Attorney General directs the board to refer to them. So, based on that, the Attorney General can pick a case, any case, pending or decided, and issue a decision that binds every immigration judge in the country.
Any case. And this has been used in ways that dramatically shift doctrine. Let's talk about asylum for survivors of domestic violence. In 2014, the BIA published Matter of ARCG, where it held that a Guatemalan woman in a relationship she couldn't escape could be a member of a particular social group for asylum purposes. Survivors of domestic violence had a presidential anchor. Then in 2018, Attorney General Sessions certified a case to himself and overruled ARCG and wrote that claims involving domestic violence by private actors generally won't qualify for asylum. So one certification, and now every immigration judge is bound the other way. No statutes to change. There's no notice and comment rulemaking. And then in 2021, Attorney General Garland certified AB to himself and vacated Sessions' decision, reinstating ARCG. Domestic violence is back as a viable basis. Then in 2025, AG Bondy certified a different case, the matter is SFFM, and used it to overrule Garland and reinstate AB. 3 swings on the same doctrine in 7 years, all through the same mechanism. Same story for family-based asylum. The matter of LEA has been certified and recertified across administrations. These aren't individual case decisions. They're substantive reinterpretations of who qualifies for protection imposed through a single referral.
And because it's binding precedent, it flows down to every immigration judge going forward.
Exactly. This is why review in immigration is so different. Review isn't just error correction, and it isn't just case-by-case consistency building. At immigration, it's also an active policy instrument wielded by a politically appointed head of a department who can reach into pending adjudications or decided adjudications and rewrite the rules. The BIA exists formally as the appellate body. The Attorney General sits above it with the power to pull in any case and change the doctrine. That's not error correction. That is policy control executed through the review mechanism.
And the reason to emphasize that structurally is that other agencies have versions of the same agreement.
Right. So the commissions and enforcement agencies have less sweeping versions. Their review authority is real, but it doesn't carry this Attorney General certification's sheer doctrinal reach. The Appeals Council at Social Security has a weaker version. It reviews little. It doesn't designate precedent. It doesn't really make doctrine like that. What the immigration example shows is what the review mechanism can look like when the agency head has both the legal authority and the political will to use it.
And that's a completely different kind of thing from what the Appeals Council does.
The Appeals Council at Social Security mostly doesn't review. The BIA plus the Attorney General certification reviews a lot, and the review includes reshaping doctrine in real time through the cases that the Attorney General selects. The variable across agencies isn't whether the review mechanism exists, it's how aggressively the mechanism gets used.
Okay, so we've talked about 2 models. How about the third?
All right, so now we're talking about enforcement agencies. This is like the SEC, the FTC, the NLRB. At these agencies, review isn't discretionary, it is automatic. When an ALJ issues an initial decision, it goes to the commissioner board by default. The ALJ's decision is essentially just a recommendation. It doesn't become final until the agency heads either affirm it, modify it, or reverse it, or let the review window expire.
So at the SEC, every single case gets a full review by the commissioners.
Functionally, yes. The commission is expected to issue its own final decision. The ALJ hearing is always preliminary. The commission has the last word.
Okay, why does this difference exist? I mean, why does Social Security, which deals with real people and real problems, barely review while the SEC reviews everything?
This is partly based on volume and partly by design. Social Security is processing millions of disability claims, and there are hundreds of thousands of appeals filed every year. It's mechanistic. It's really impossible for the Appeals Council to meaningfully review every case. The SEC ranks maybe a couple hundred enforcement actions a year, and 5 commissioners can genuinely look at a couple hundred cases.
Okay, so at one end, you have benefits claimants who mostly get no meaningful review, but at the other end, you have enforcement respondents who get guaranteed review by the same institution that brought the case against them.
Both of those sentences are doing work in that trade-off. We'll come back to the second one in a minute, but first I want to stay with this. So in each of the 3 models, the review body exercises selection power over its docket. This is a big deal since it's a structural feature of agency review that courts don't have.
Okay, because courts don't get to do that, then they take what comes to them?
Yeah, so think about how a circuit court gets cases. The parties appeal, the court gets whatever the parties bring. The Supreme Court can deny cert if it wants, or it can issue summary affirmances, but historically, it can't reach down into a trial court's docket and pull up a case it wants to decide. The court is working from the pool of cases that other people brought.
What about the agencies?
So agencies can reach. The Appeals Council can review a Social Security case on its own motion, even if nobody appealed. The BIA can do the same. The SEC Commission can initiate review. And the Attorney General, as we saw, can certify any case and decide it himself.
So this is really about what the reviewing body picks.
Right. And that isn't a small thing. In a court system, we have law that develops because the litigants themselves decide to push the question up. The Fifth Circuit rules on the cases that come to it. Parties can force the court to confront a question by appealing. That gives litigants a meaningful role in how the law develops. They pick which issues get resolved when.
And in the agency system?
The agency leadership picks which questions reach the precedent-making level, which facts get adjudicated at that level, which doctrines get announced. The president is curated from the top down, not pushed from the bottom up.
So the selection is its own form of control.
Yes, and it is a significant form of control. So an appeals court can decide which decisions are going to be precedential, but it still is going to have to address every issue. But if the agency wants the law to develop in a particular direction, it can just pick the cases that go in that direction. The Attorney General's certification power is the most visible version of this, but every reviews body exercises some version of it. Deciding what to review is deciding what becomes law.
Which means the review layer isn't neutral error correction. It's a mechanism that combines error correction with agenda setting.
Yes. So the textbook version of internal review would treat it like quality control. The agency had sample and correct. The real version is agenda setting plus quality control, plus, at least the enforcement agencies, a structural conflict we haven't talked about yet.
Okay, you flagged this a minute ago, but let's get back to the enforcement side.
Yeah, so at the SEC, the commissioners oversee the enforcement division. They approve investigation targets, they set enforcement priorities, they allocate resources to the enforcement staff, and then they serve as the appellate tribunal reviewing whether that same staff proved its case.
Okay, so the investigator-adjudicator overlap we've been talking about at the institutional level.
Right. So in an ordinary appellate system, the reviewing body has no institutional stake in the dispute. The Ninth Circuit isn't supervising the plaintiff's lawyers. The D.C. Circuit doesn't set policy for the agencies whose rules it's reviewing. Enforcement agency review looks completely different.
Okay, how does that pattern show up in the data?
So when the SEC reverses the ALJ's decision, the large majority of those reversals, about 3/4, favor the enforcement division. They're either finding violations that the ALJ didn't find or increasing penalties that the ALJ imposed.
So when the commission steps in, though, it usually goes against the respondent.
Yes, and you don't necessarily need bad faith to see why. The enforcement division works for the commission. If the commission regularly rejects enforcement cases, they're effectively telling their own staff they're getting it wrong. The incentives line up in one direction, and they do that without anyone necessarily acting improperly.
And they're exercising that while applying all the powers authority to redo credibility from a transcript.
Yeah, so we have this combination where the reviewing body has an institutional preference, and the review includes the authority to overturn credibility findings made by someone who was actually in the room. And that's not really a neutral error correction mechanism. That's something else.
Okay, what about the benefits agencies? The Appeals Council doesn't have the same prosecutorial stake in those cases.
Right. So nobody wins if a claimant loses at the Social Security Administration, but the Appeals Council operates within an agency that has budget constraints, that has processing targets, and institutional views about how disability standards should be applied. If agency leadership believe the ALJs are being too generous, the review function can become a tool to sort of tighten the outcomes. The structural pressure is different from enforcement, but it's not absent.
Okay, is there a counterargument to all of this? I mean, because I can hear someone saying, of course, agency heads review their own agencies, ALJs. They're the experts. They're accountable. Somebody has to be the final word.
So, yeah, that's really three arguments. We have expertise, that the agency heads know the statutes and regulatory landscape better than anyone, and that without review, these ALJ interpretations would drift in different directions, as we saw, which they do in the last episode. And we've got accountability, that agency heads are politically appointed by the president, so they're more democratically accountable than career ALJs. And we've also got uniformity, that without this, different ALJs interpret the same statute in different ways, with no real mechanism to reconcile them.
Yeah, and those sound like practical arguments, though. Do they really answer the due process concerns?
They're arguments for why we want some form of central review. They don't answer the question of what to do when that review is institutionally tilted. The system that the APA built leaves that question open.
Okay, let's try to pull these three models together because I want to make sure I'm seeing what unifies them.
Fabulous.
All right, so at Social Security, review mostly doesn't happen. The ALJ's decision stands, hearing level variation is preserved, not corrected. At immigration, review does happen, sometimes in depth, sometimes it produces binding precedent through designation or AG certification, but the selection of what to designate or certify is itself politically directed, and doctrine can shift with administrations. And at the SEC, review happens in every single case, but with a structural institutional lean towards enforcement division.
Yes, and none of those three models primarily produce consistency. Not by design, not by accident, not as a side effect of doing something else. Each one fails to produce consistency in a different way. So Social Security Administration fails by not reviewing most cases. Immigration fails by reviewing through a mechanism directly controlled by political leadership whose priorities shift with administrations. And enforcement fails by reviewing through a body that has an institutional stake in the outcome. We have these different failure modes, but the same bottom line. Internal review is not the mechanism that pulls similar cases towards similar outcomes.
So review can correct egregious errors. It produces some precedent where precedent gets designated. It's not zero, but as the mechanism that's supposed to fix what the hearing level couldn't, which is what the textbook description of internal review suggests, none of these three models is doing that work.
Right. So they're all going to correct some errors and resolve some conflicts and potentially produce some precedent. It's not a system with zero value, but as a mechanism for ensuring that similar cases come out the same way, which is the thing a listener might hope for after last week's episode, it is not that.
So it's not the fix for the hearing level picture.
Right. So now we've covered two layers. We've talked about how ALJs don't produce consistency on their own. That was last week. And that the review layer doesn't really produce it either. That's this week. And neither of these mechanisms, the formal adjudicated system was built around, produce the thing we potentially want from it most, that consistency. And yet agency preferences do translate into outcomes. Aggregate approval rates shift across administrations. Enforcement priorities become enforcement outcomes. Doctrinal positions announced by agency leadership become practice.
Which means that whatever is actually producing those patterns has to be operating somewhere other than where we've been looking.
Right. So agencies don't have to wait for appeals to shape outcomes. They shape behavior before the ALJ even decides the case. Through metrics, through performance reviews, through guidance that can function like law, even if it's technically not, and through the quiet institutional pressure that comes with working inside a hierarchical organization where your bosses have views. That's what we haven't really looked at yet, and that is the next episode. How agencies actually control outcomes, not by correcting decisions, but by shaping the conditions under which the decisions are made.
So that does it for today's episode on administrative remedies. Thank you for joining us today. Please, if you enjoy this podcast and enjoy this episode, give us a like on Spotify, iTunes, or whatever platform you're listening on. And be sure to tune in next time where we'll continue to dive into the contours of administrative law because remember, you can't fix what you don't understand.